Forming a holding company is a great way to inexpensively and easily increase your asset protection and privacy. A holding company is not a special kind of LLC. A holding company is just an LLC that owns other companies. The holding company does not engage in any liability producing activities and acts as a buffer from that liability flowing to the owners. Ultimately, if there is any litigation against the subsidiary, that's what the holding company owns, then that litigation would stop at the holding company level and could not get to the owner's personal assets. So it's a protection that is fairly easy and inexpensive to set up. There are some questions that arise related to the holding companies. Is it required to have an operating agreement? Do I need an operating agreement if it's not required? What should that operating agreement contain to enhance asset protection? Operating agreements are not required under the laws of most states. An operating agreement is optional. So if you do not adopt an operating agreement for your company, then the default laws built into the Limited Liability Company Act will apply to your company. That may work out great. It may not work out so great, depending on whether you like those standard provisions of the Limited Liability Company Act or not. While it's not required then to adopt an operating agreement for your holding company, we do recommend it. It is important to have a signed agreement for a number of different reasons. One would be that you can show this is a real company that actually executed a document that governs how its affairs are managed. It's not required by the law, but we do recommend having one. The next question is, what should it contain? An operating agreement should contain information about who owns the company, who has authority to manage the company. We do recommend that you adopt a manager-managed limited liability company operating agreement because it can provide enhanced asset protection. If there is a dispute against an individual member of a holding company, then the individual member can remove themselves as a manager of the company and allow a third party to manage the company. This can remove jurisdiction over the LLC itself from the courts in which that individual member is being sued. Finally, are there any things in particular that should be included in the operating agreement for the holding company? And our answer is yes. We have identified a number of cutting-edge techniques that we build into all of our operating agreements that will protect the members from excess liability flowing to them. They will prevent veil piercing. They will prevent someone from taking control of the limited liability company in a way that perhaps is not approved by the current owners. So there's a lot of things that can be included in an operating agreement, and all of our basic operating agreements include them. So to summarize, it's not required by law to have an operating agreement for your holding company, but we think you should, and it should likely be manager managed, and it should contain cutting edge provisions which serve to protect the assets of the individual owners as well as protect the assets of the subsidiaries.